Good morning, everyone. I welcome you all to the first panel discussion of today's symposium on aviation law and practice. But before we begin with all the presentations and the presentations by the people present on this panel, I would like to request Professor Dr. Sandeepa Bhatt sir to kindly felicitate the members of this dais on our behalf. To begin with Dr. Jessica ma'am. Yep. I would now request Dr. Sandeepa Bhatt sir to kindly felicitate Mr. Kiran Mohan sir. Now, I request sir to kindly felicitate Dr. Banerjee. Yep. And so lastly, on a concluding note, I would request Dr. Sandeepa Bhatt to please felicitate Dr. Gurbachan Sachdeva sir. Uh, to begin with, our first panelist among the a very diverse set of panelists on the very first panel discussion of today's symposium on aviation law and practice. I would now like to begin this by giving the floor to Ms. Professor Dr. Jessica. Dr. Jessica is a professor of international law as well as business law, and she has flown all the way from Indonesia to be present here with us today. She's also a member of the Philippine Bar and the International Institute of Space Law. And ma'am, we would request you to shed some light on the notion of rougher skies and the imperative for clarity of passenger rights in Indonesia and the Philippines. Thank you so much.
Okay, good afternoon, everyone. As introduced, my name is Jessica Los Baños. I'm from the Philippines, actually, but I have worked in Indonesia for the last 15 years. So it's a pleasure, and before I begin my presentation this morning or this afternoon on the topic of rougher skies and the imperative for clarity of air passenger rights and protection in Indonesia and the Philippines. I'm just using them actually as reference countries, but my interest has always been in policy. And so before I begin the presentation, I would like to thank Dr. Sandeepa Bhatt for the kind invitation, and also the organizers, the Center for Research and Space Law from the 3 universities across India, and I've heard that these are the most prominent universities in regard to air and space. And so thank you very much for the kind accommodation. So my interest has always been, as I said, policy, and the first topic that we will be covering this afternoon is, and I will be presenting, is on air passenger rights. And this is, I'm sure, very dear to you because we have all flown at some point in our lives. Coming here, for example, a number of you took an airline. And so the issue of clarity of air passenger rights is really very critical, particularly now that the pandemic has actually ended, and so the IATA has shown that there will be more flights out there around the world, and in fact, the level of air traffic has increased and almost reached around 97% of pre-pandemic levels. And secondly, also, there's a reference to rougher skies because of climate change, and climate change has, as we do know, has led to a number of weather disturbances, and these weather disturbances have then led to a large number of cancellations. Even in the US, the cancellations range as far as around 10 to 15%. And so it is very timely indeed for us to address the issue of clarity on space rights. But there's a more personal reason, actually, why I wanted to discuss this topic when Professor Sandeep asked me to choose a particular topic. I'm also very much interested in drones, but I thought this time I wanted to talk about air passenger rights. Why is it very close to me? Because in the last 15 years, I've been assisting on a pro bono basis. Because of visa considerations, the travel issues of my friends and my friends' friends. And so it has become a very close issue to my heart. So in the next 15 minutes, I'll be talking about what is it that passengers really want in their flight, and basically then move on to, if you can see the second set of slides there, it would be on I would then talk about the role of international law in air and passenger protection, and then I would sort of present to you a quick look and a comparison between Indonesia and in terms of its legal framework, as well as the rights that are actually respected or promoted in Indonesia. And finally, because of my policy interest, in moving forward, I will discuss the imperative for greater clarity and transparency. So what do passengers really want? Just 2 months ago, my friend, who was actually supposed to travel from Philippines to Canada, actually had her flight canceled when she was already in the second leg of her flight. And during that time, she was told that there was nothing they could do about it, and she knew that she had to be in Canada, she had to attend a wedding. And so the wedding was the next day, and so she had that issue, and she didn't want to leave the airport. And so it took around 6 hours before they were able to settle the issue. And so what was their settlement? So the settlement was really very simple. Free accommodation, which was rightfully due her. And then she was asked to choose whether she wanted $100 or 20,000 miles, and also a rebooking of her flight without additional costs. And she said, "What do you owe me?" And that was the question. But the airline representative just said, "What do you want?" And so it really goes to the very question, what do passengers really want from our airlines? And so, as most of us have traveled, we want comfort, we want timeliness and reliability, we want convenience, and of course, we want safety. But when there is a flight disruption, we want fair compensation and treatment. So for our priorities during flight disruption, we want, for example, our rerouting to be seamless, and of course, compensation to be paid when it is relevant indeed. And so the air industry is a very mature industry. So that means there's a lot already of regulation. So the international law framework in regard to air passenger protection and consumer protection is quite established. So the role of international organizations, for example, like the International Civil Aviation Organization, the IATA, they have all laid down very specific rules how airlines are supposed to protect their passengers. And they have actually designed their framework sort of following the layer for law students who are here with us. We do know that international law is really very nuanced. So an international law is created where you have two regimes. The traditional regime, which is really the relationship between states, and the new layer for law students, law is really very nuanced. We do know that international relationship between states administrations and already became parties to the convention. But the more challenging problem is how these laws or these norms that are set under the Montreal Convention and the other conventions that apply are actually implemented by domestic law. And so, let's say, for example, you will see on the screen the Montreal Convention 1999, which is the latest the one on the unification of carriage of passengers, goods, and individuals around the world. We can see that indeed it is strong. The regulations are strong, and in fact, Article 49 of the convention actually is very specific that as far as the mandatory application of the convention, any clause that airlines enter into in regard to the contract, if I may read it, in regard to the contract of carriage and all special agreements entered into before the damage occurred by which the parties purport to infringe the rules laid down by the convention, whether by deciding the law to be applied. And so this is where the problem really is centered on, by deciding the law to be applied, and this is a reference to private international law, or by altering the rules to jurisdiction, and this has to do with access to the courts, shall be null and void. So there is really strong protection as far as whether or not we are entitled to certain rights for our protection of our consumer rights under international law, being passengers of airlines around the world. Now, the second important provision for airlines is that they have to take insurance. And of course, this would mean that they shall require all their carriers to maintain adequate insurance to cover their liabilities under the convention. And the convention's liabilities are actually very clear. So if I may move on to discuss what are some of the frameworks for, let's say, the liability convention, we do know that it covers death and injury of passengers. So if you must know, if you, unfortunately, a relative or somebody were to die, there is a strict liability regime, and we all know this. So whether you are a small airline, a cheap or a low-cost airline, or an expensive airline, it's a two-tiered regime. So you're entitled to 100,000, and the number has been adjusted already, to around $177 equivalent in special drawing rights. And if you are going to ask for more, you will really have to prove extraordinary circumstances, and this would have to do with whether or not you have, you will be able to prove whether or not the airline has been at fault, or you will not be entitled to pay for additional compensation if you are also at fault in your passage. So the rules are quite clear as far as the death or the injury of passengers, but the problem lies in the flight cancellations, because nobody dies all the time. The aviation law is the safest in the world, very, very rare to have a number of crashes. In fact, 0.00% actually, perhaps, or very, very, very small, very minuscule rate, and so it's the safest mode of transportation. But the problem really lies in the bulk of the issues that a common passenger faces, which is really delayed baggage, flight cancellations, and so on. And so here, the challenge is in the fact that it is not compensation similar to the death or injury, but it is damage. So that means the burden of proof is on you to claim damage. And the practice of states have been different in regard to this, because if you look at the Montreal Convention, it doesn't really provide for floors. It provides for upper limits. And so what this means for airlines and for states around the world, they could give us very low as $100 for you in their laws, in their domestic laws, for you to be able to claim, even though you would have suffered a lot more. And it would be very, very tedious for you to then file a case before the courts. And so in regard to the Philippines and Indonesia, as far as the legal regime, just to give you a very, very quick comparison, for Indonesia, their law currently, which has to do with aviation law, I don't know how much time do I have, they would cover only domestic passengers. And so there's really no clarity in regard to their rights under international law. And for the Philippines, which is governed by the Civil Aviation's board regulations, so particularly Regulation 7 and 9, there is a very much limited reference to to international rules that apply. So for us, for example, international passengers are entitled when you have denied boarding, in this particular case, denied boarding, you're only entitled to 100% of the value of the sector that you have not flown, plus $100 of the equivalent currency if you have been denied, or in the case, for example, of a flight cancellation, the rules are even hazier because they can then negotiate, as it can be shown by the experience of my friends when they, and my sort of friends and clients when they were dealing with the airlines. And so this leads us to how do we make states to account for making sure that international regulations are actually implemented in domestic law properly. And that has always been the problem also in the Philippines and in Indonesia and around the world. And I call it the implementation trap. I've always looked at how we need to have smart regulations, regulations that actually ensure that we are able to follow through and ensure that the rights of the individuals and the beneficiaries of the law actually are accorded to them and respected all the way until the transaction for which the entire legal regime applies is actually completed. And that is the main issue. And for example, let me just, I know because you cannot see the slide, so I've sort of changed the discussion a bit. So I would say that moving forward now, I'm into my last set of slides, moving forward and really going back to the question on whether there is, what is that imperative for greater clarity and transparency? It is really very, very important. Let me just also share with you the experience of an airline, Filipinos in Dubai, where they were not allowed to board the flight. It was canceled, but they were not given anything. And so it was really a very big issue as far as the Philippines and the social media was concerned. And a number of them are poor and just overseas Filipino workers and did not have the capacity to actually pay for accommodation and all that. And so they stayed at the airport for the number of hours they had to wait before the flight was actually rebooked. And so a number of them asked me whether or not, what is the applicable law to them? And of course, even though I may know the law, but the people who are there in front of them don't know the law. They would have had to ask for a person in charge for them to be able to then state to them what are their obligations, both under domestic law and under international law. And because this is an international carriage, it's much made more complex because of the rules of private international law. So if you have plans to actually file a case, you will then have to see what laws you would expect to apply. It's good because you can form shop, so to speak. It's good you can choose because some laws cover flights to and from the destination. There are some laws that only cover flights departing from a particular segment or a particular territory. But again, it is really very important that our airlines and our states do then ensure that there is very strict compliance, and particularly because the legal regime is a bit more designed in favor of states and for the states to then design their own legal systems based on their own capability, even though we do know that the goal of the Montreal Convention and the ICAO is to ensure that there is harmonization of rights, such that it should not matter where you are in every part of the world, you should be given the same rights and the same privileges, whether your flight is canceled, whether you are denied boarding, whether, of course, your baggage is lost. But unfortunately, the system is not also very clear. And I would just like to highlight a second problem for developing economies. We do not quite sort of our database and management systems are actually very poor. So we are very poor in evidence-based monitoring, and so we are not quite able to respond to our people's interests. And so I think that is where the law should go as far as the states are actually concerned. And so let me end there. There are actually, in terms of designing the legal regime, there is now the trend. Let me discuss the trend in how passenger rights are actually protected. We're currently a claims-based regime. So there are efforts towards a more automated compensation and care assistance regime. So for example, just last month, the state of Canada actually said that they are going to create new laws that would sort of reverse the burden of proof on the part of passengers. Instead, it would be the burden of proof will vest on the airline to actually prove that it is an extraordinary circumstance. And I do hope, it's really very visionary, and this has been discussed by a number of our colleagues, that there should be a common system, particularly for mass disruptions, because we do know that for force majeures, airlines are not responsible. So I think states should also make sure that they are able to provide for mechanisms and plan ahead. And that has been a very major issue in the case of the Philippines, and I hope developing economies are able to address this as well. So I think that ends it for me. So thank you very much. I hope that you did learn something from me this morning. So thank you very much.
Thank you so much, ma'am, for giving such a comprehensive debrief on the persistent notion of state accountability, especially in the niche field of aviation law. And before I invite Dr. Sandeepa Bhatt sir for his panel, sir has led the Center for Aviation and Space Laws at NUJS, and his academic record has been at a National Law School as well as NUJS, and having been a part of projects that have been sponsored by not just the World Bank but ISRO as well. Sir has written over 4 books on aviation law. So now I invite sir to begin with his panel.
Thank you. Very good morning to all of you once again. And I should also thank Jessica for setting the platform for my discussion, because my presentation here is also in terms of the implementation of an international law regime into the municipal sphere. How exactly India is under a fallacy with respect to a Cape Town system. Right, so I think Jessica has mentioned about actually the Article 49 of the Montreal Convention, which basically speaks about the application of the Montreal Convention in the domestic level. So I'm trying to address that with my own argument, to be very precise, with respect to the Cape Town Convention, which is on the financing, aviation financing aspect actually. Right, and I should also tell all of you, whoever are here, that the aviation financing is one of the most significant practical aspects of the aviation law. There are multiple other things. I was also discussing during the break with some of the participants that aviation law has got a lot of practice, but the only thing is that most of them go to the consumer fora. That's the reason why most of us are not aware of the cases, the number of cases actually which are fought in the consumer courts. We all think about the High Court and Supreme Court, but these cases don't go to there. They will go actually to the consumer courts. So precisely because of that reason, we are not aware of the extent of practice which is going on in aviation law. And when I tell about the aviation law practice, something which is of the most significant aspect at present is the financing. Right? It might be financing, leasing of the aircrafts, all those aspects are together, which is dealt under the Cape Town system. Can you go to the next slide, please? Right, huge investments. I need not elaborate on that. You must be knowing that it would be a multi-million dollars investment, or sometimes even a multi-billion dollar investment in the aviation sector. And the airlines would not be having the assets to pledge as the collateral for procuring the loan. Right? So $1 billion, you cannot get it actually by pledging some property which belongs to you. Rather, what has to be done? You may have to pledge something for which the finances are sought. Aircraft, right? That's called asset-based financing, ABF. Right? The asset which is being financed itself is used as a collateral for the purpose of actually procuring the loan. Now, this is quite different from the traditional financing, because in traditional financing, you have the creditor having the possession of the collateral. You pledge the gold, the bank will have actually the gold as a collateral in its custody. You pledge the property deed should be there in the bank, right? So they will be having actually the custody or the possession of it. But in the asset-based financing, it is the debtor who will be having the possession of asset. Just like what we have in India in the form of hypothecation. You must have seen in different cars or maybe in the buses and all, hypothecated to State Bank of India, hypothecated to Union Bank, etc. Right? So they have taken a loan and they have purchased the vehicle. They are running the vehicle, the owner is running the vehicle, but the right would be with the creditor. It's a kind of a non-possessory security interest. Interestingly, this non-possessory security interest is recognized only in certain jurisdictions. Don't think that what is applicable in India is also applicable across the world. Especially, this is because of the distinction between the common law countries and the civil law countries. Common law countries do recognize the non-possessory security interest like this, right? But at the various levels, some of them fully, some of them partially. So we have actually the limitations. Some of the civil law countries don't even recognize the non-possessory security interest. If you go to the court of law, they will simply say that, no, get out. We will not recognize this kind of an interest. Right? And some of them in a very limited manner, they would not provide the self-help the right. So the creditor cannot actually take the possession of the asset unless and until there is a court order. He has to go to the court, spend the time, get an order with respect to actually getting the possession of the asset. So that's how at the different countries, you are finding the different kind of approach to the non-possessory security interest. And this is the biggest problem. This is the biggest problem. Can you go to the next slide? Aircraft equipment cross the borders. They cross the borders, right? There are, of course, not just the aircraft equipment, even the space assets, railway rolling stock, etc., they cross the border. Problem is that when they have crossed the border, and if the debtor fails to pay back the money to the creditor at that particular point in time, debtor makes the default to the creditor, creditor is supposed to exercise the remedy, right, by taking the possession of the asset or maybe actually realizing certain kind of interest over the asset, etc. The creditor is supposed to exercise the remedy. Unfortunately, the asset might be in a place which is not recognizing the non-possessory security interest. Right? And if you go by the private international law or so-called conflict of laws rules, that clearly says that in case of tangible movables, you're going for lex fori and lex loci. The jurisdiction would be with that of the state wherein the object is found at the time of the default, and the applicable law would be that of that particular state. When you apply the applicable law of that particular state, which might be a civil law country, not recognizing the non-possessory security interest, creditors' interests are gone. That is the biggest risk which the creditors are going to take in case of the tangible movables. Movables in the sense from one jurisdiction to another jurisdiction, one state to another state. Right? That's the biggest problem which we are having in the aviation financing. And there's a possibility of misuse by the debtors also. They might do the default intentionally at a point in time when the aircraft is in a civil law country which does not recognize the non-possessory security interest. That's the biggest risk. Next slide, please. Added to this, even if actually the asset is in the common law country which fully recognizes the non-possessory security interest, still there is a problem. Because this huge investment in the aviation sector or maybe even in the space sector for that matter, that would come from the creditors from multiple jurisdictions. An Indian debtor carrying on an aviation activity in India would not be able to find the finances only within India. He should be taking the finances from maybe a US creditor, Japanese creditor, Russian creditor, or French creditor, so on and so forth. Each one of them is governed by an independent contract. There is no uniformity in contract, independent contract. Right? Only the debtor and the respective creditor knows what is the contract, what is the terms of the contract. Debtor might have agreed in each of these contracts different applicable laws. With the US creditor, Indian debtor might have agreed US law is applicable in case of actually any kind of a default. With the French creditor, French law. Right? With the Japanese creditor, it might have been agreed that the Indian law is applicable. Russian creditor, some other law, whatever it may be. So they might have agreed for a particular applicable law. Suppose if the debtor makes the default to all these creditors at one go, everyone would jump on and they would try to actually exercise their remedy over the asset. Especially when the asset's value is less than the loan which has been taken by the debtor. Suppose if the debtor has a loan of $1 billion, the asset which he is having is just 500 millions. In those circumstances, what happens is that everyone would like to get back the money first. Those who are running into the priority in terms of the return of the investment, they will get back their money. But after $500 million, nobody is going to get back the money. Those who are in the bottom of the priority, they will lose out their interest. That is why everyone would like to run into the top of the priority. They will say that in my contract, my law is applicable. My law says first come, first served. One of the country's laws may be first come, first served. Whoever has actually first financed would get back the money first, second, third, fourth, like that. It might go on like that. But in another jurisdiction, there might be a distinction between secured creditors and unsecured creditors. Secured are going to get first, then you're going for the actually unsecured creditors. There might be some jurisdiction telling about registration. Whoever have registered the interest, they will get back the money first. Unregistered would be all subsequent. Like this, different jurisdiction would be having different applicable laws, resulting in complete chaos. Who will have the priority? Right? That is the biggest problem in the aviation the financing. Next slide, please. So, these problems, especially emanating from the multiplicity of the laws, has been tried to be addressed by unit droit. It's a French word, unit droit, not unit droit. Right? So, unit droit has tried to address this with the two-tier structure system. The Cape Town Convention, which I was basically referring, the Cape Town system. At the top level, they have a basic treaty. That's the Cape Town Treaty of the 2001, Cape Town Convention of 2001. All general norms with respect to the financing, especially in terms of mobile equipment. Mobile equipment includes aircraft equipment, railway rolling stock, space assets, etc., because they have moved from one jurisdiction to another jurisdiction. Mobile is not something moving within the jurisdiction, one to another jurisdiction. So with respect to them, UNIDROIT has brought all fundamental aspects in the convention. Then, each area, specific areas like the aircraft area or maybe railway rolling stock, etc., they have brought a separate protocol. Aircraft protocol, railway rolling stock protocol, space protocol. Now there is an addition of MAC protocol that is on actually mining, agriculture and construction equipment protocol. They have added the fourth protocol actually over the period of the time. How do you read this system? You have to read it in such a way that you will read the base convention along with the respective protocol, like for aircraft equipment, Cape Town Convention with the aircraft protocol. Together you have to actually read it and find out what is the regime applicable to the aircraft equipment. So that's how it goes on. And on aircraft equipment, it has actually already come into existence. Next slide, please. So obviously the UNIDROIT system or the Cape Town system is for the purpose of strengthening the financing, ensuring that the creditors are going to have a confidence in financing and they will actually pump in investment with respect to the aviation sector. Of course, railway rolling stock and the space asset have not come into existence. They are still in actually the process of ratification. Only the aircraft equipment has come into existence. Railway rolling stock, in the beginning of this year, Spain has ratified it. It is the fourth country. And as per the protocol, after the ratification of the fourth country, within 3 months, it is supposed to come into force. But if you look into the UNIDROIT's website, still it says yet to enter into force. I don't know what is the reason for that actually, but still it shows it's yet to enter into force. Anyhow, on the aircraft equipment, it has already entered into the force. Number of ratifications have already happened. India acceded to the this particular system in 2008. We are parties to the Cape Town system, especially with respect to the aircraft financing. However, despite that, we are having a lot of problem in terms of implementation. Bankruptcy proceedings actually starting from Kingfisher, Jet Airways and GoFirst also of late. Every time the foreign creditors had got a lot of difficulty in terms of actually the deregistration of aircraft and getting the possession of the aircraft. Professor Shantakumar was referring to that in the morning the speech, that IBC, Insolvency and Bankruptcy Code. That is one of the biggest problems because the court order has to be taken, deregistration has to happen, and the civil aviation civil aviation actually the organization in India, in many of the circumstances has rejected actually the deregistration. If the aircraft is not re-registered, you cannot take it back to the country, right? There is no possibility of double registration of an aircraft. Chicago Convention makes it very clear about that. So you can't go for that. So that's why deregistration is a problem. Taking possession and getting it back immediately is a problem. And this would be very, very crucial for the creditors, because if an aircraft is lying in the airport for, say, 3 months or 6 months, it would be having the depreciating value, right? The engine becomes actually, they say, something defunct, so consequently you might not be able to fly it. Without the regular maintenance, you might not be able to do that, right? So precisely because of that reason, getting immediate remedies in case of default by the debtors is the most significant aspect for the creditors. The Cape Town system tries to do that. India has acceded to it. Unfortunately, it has not implemented it properly in the domestic level. Just a couple of days back, there is a notification, as Professor Shantakumar has mentioned, that Section 14 of the IBC would not be applicable in case of aircraft repossession, etc. But still, there are other aspects of the Cape Town system which have not been implemented in India. Next slide, please. 2 bills have been actually tabled. 2018 Cape Town Convention bill was actually prepared. And 2020, of course, it has lapsed also. It has not been actually accepted in the legislature. 2022 protection and enforcement of interest in the aircraft objects bill of 2022 has also been actually prepared, tabled also. But nothing has happened till now. Unfortunately, both of the bills have got a lot of problem, and that is not on the basis of the proper understanding of the Cape Town system. I will not delve into that because that would be a separate matter of discussion, and I don't want to bore you with another 15 minutes or 20 minutes on that. Let me just wind up with the last slide on actually what is my argument. Please go on to the last slide. My question is more fundamental. Do we need a law? We are actually trying to enact the bills, right? The 2 bills which I basically pointed out. Do we need a law for the purpose of enforcement of a private law convention like the Cape Town Convention in the domestic level? Everyone may say that, oh, we are specific adoption theory state, we are a dualist. Obviously, we have to implement that with the specific legislation. Parliament has got the power under Article 243 of the Indian Constitution. Everyone might lecture on that. I agree. I completely agree with respect to any domestic, actually the creditor. If there is the Indian creditor who has financed an Indian debtor in India, yes, you might require a domestic law for the purpose of implementation of Unidriva system in the domestic level. I agree that. But whenever a foreign element is involved, if it is a foreign creditor who has financed actually an Indian debtor, we cannot say that our domestic law is not there with respect to this, and therefore we are not going to give any remedy to the creditor. Then what is the purpose of we signing a treaty at the global level? Purpose of signing the treaty at the global level is to ensure that actually we are going to follow in our international law, not the domestic law. That is the purpose, right? And it is very clear under Article 28 of the VCLT, Vienna Convention on Law of the Treaties, which speaks about pacta sunt servanda, right? So we have to respect our treaty obligations in good faith. We have to respect our treaty obligations. In an international relation, in the domestic level, whatever we do, it is our domestic affair. We need not actually follow the international law. But whenever a foreign element is involved, we have to go by the pacta sunt servanda for the purpose of implementation of international treaty. You might ask me, why are you quoting VCLT? We have not ratified VCLT. You should also be knowing that 26 has become part of customary international law. There is no doubt on that. Pacta sunt servanda has been considered by everyone as a part and parcel of customary international law. As a universal custom, it is binding on us. It is supplemented also by Article 27 of the VCLT and Article 3 of the RCIVA. Articles on international responsibility for the wrongful acts, state responsibility for wrongful act. Both of them specifically say that you can't defend your action on the basis of a contrary municipal law. If you have done a wrong, you are at wrong. You cannot say that actually I have a municipal law which is contrary to this. That is the reason why actually I am justified in doing this particular action. That is not permissible at all, and both of them are also part and parcel of customary international law. Both of them are part and parcel of customary international law. So this is why my argument is that in terms of international financing, we would not be able to say that there is no domestic law. That's the reason why we are not implementing actually the Cape Town, the system. I should say that we should come out of this fallacy of requirement of specific adoption, especially with respect to the international creditors. That's all. Thank you so much.
I think in the morning itself, Professor Dr. Sandeepa Bhatt as well as Dr. Shantakumar sir had made it very evident that Cape Town Convention is going to be a legislation that's going to be heavily talked about and opined on during the course of this symposium. And also, thank you so much, sir, for talking about aviation financing, which as of now looks like the most employable sector of aviation sector also. And before I invite Mr. Kiran Mohan sir, sir is a senior legal officer with the Asian African Legal Organization, and sir's forte in aviation and space stems from his graduate fellowship at McGill University. And I would now like to invite sir to speak upon the examination of aviation's impact on environment and the carbon set-off program.
Thank you, Prakrit. Before I start, it's truly an honor and a privilege to be on the dais with my teacher, Sandeep sir, and the likes of Dr. Sachdeva, Dr. Banerjee, and Dr. Jasika. I would like to start on a lighter note with a cartoon of sorts. Can you move to the next slide, please? Oh yeah, yeah. Before that, I will have to make a disclaimer as well because, yeah, I've been clearly told to do so by my employer. So, okay, yeah. So I will be speaking on my personal capacity, and any views I present here will not be reflective of the views or positions held by my employer, Asian African Legal Consultative Organization, or its member states. Now that's out of the way. I will move on to the presentation, and I'm waiting for the first slide. Yeah, no.
Blessings I'll see.
Yeah, you're finally there. uh, so imagine that you and your partner, after a year of hard work, say in your law firm, finally decided to take that much needed vacation in Bali, and you've booked your tickets, and you shared your enthusiasm of that vacation with your colleague. That colleague, instead of sharing your excitement, in fact takes you through a guilt trip over the emissions, the flight you're taking to Bali, leaving a lasting legacy on the climate change that we currently face. Now, there's a term for that. It's called flight shaming. Most of you must have heard about it on social media or on TV. And these terms entered into the popular discourse predominantly through the efforts of this young lady known by the name Greta Thunberg, when she one day decided to come out against aviation, especially international aviation, and instead advocated for traveling on trains or buses. Now, these points to a very serious issue. The industry has a view about it. International aviation lawyers certainly do have a view about it. And climate activists have an opposite view about the same issue. Before I move on to the legal institutional mechanism, namely COSIA and EU emission trading scheme that is the core of my discussion here, let me give you some grim facts about the pollution aviation, especially international aviation causes. The graph on your screen, it talks about how aviation, international aviation, contributes carbon dioxide from as early as 1940s till 2018, and there has been a significant increase in the contribution of aviation to climate change and global warming. Now, if you consider the amount of carbon international aviation emits, if that were a country, it would constitute one of the top 10 polluters among nations. Next slide, please. So emissions from international aviation, they have increased almost by 130% over the past 20 years. That's the figure from 1992 to 2012, actually. By 2050, despite improvement in fuel consumption, air emissions are expected to be 7 to 10 times higher than the 1990s level. And IATA is hoping to double its passenger traffic, international passenger traffic, between 2020 and 2025. So if things are left unchecked, a quarter of global carbon budget, that's according to what we agreed, international community agreed in Paris, international aviation would constitute 25% of it. So what is international community doing about it? And the problem is not just about carbon. There's a ripple effects of sorts. Carbon is just, as you all know, one of the greenhouse gases. There's water vapor, which is more intensive in terms of its contribution to greenhouse effect than carbon dioxide, in fact. And there is nitrous gases, and there is contrails that aircraft leave. So all of them together causes this burgeoning effect, if left unchecked, would prove disastrous to our climate mitigation efforts. So there are a few technological and institutional legal solutions that are being talked about these days. One is fuel taxes. Of course, we're paying higher fuel taxes uh, in the last 20 years, mostly as dictated by the green policies of respective national governments. Then there is greater advocacy for sustainable aviation fuel, including biofuels, and companies, especially the big ones, Boeing and Airbus, have been investing a lot on greener technology, making their engines more fuel efficient, and thereby emitting less gases, including carbon dioxide. Uh, but what we are talking about today is about institutional mechanism, international institutional mechanism that are constituted under one ICAO, the International Civil Aviation Organization, which is the UN-mandated body that regulates international civil aviation, and the European Union. Let me first talk about carbon offsetting. So COSIA, the first international institution that I'm going to talk about, is essentially an international carbon offsetting mechanism. I will contrast that with the EU emission trading mechanism, which is a cap-based mechanism in the later part of this presentation. But let me first explain what carbon offsetting mechanism is. It, in simpler terms, is about feeling less guilty about your emission, about giving money to more meaningful, I mean, that's debatable, and less, more efficient environmental projects that contributes to lessening greenhouse gases in other sectors. So in our case, that would mean airlines companies funding environmental projects in other sectors in tandem with or in consonance with the amount of emission they release. So that's essentially carbon offsetting. And COSIA, which is Carbon Offsetting and Reduction Scheme for International Aviation, which is an ICAO made measure. It's a market-based measure which has been adopted in the among the participating states. So it essentially lets airline acquire offset credits for funding their environmental initiative to compensate for their own emissions. The goal is to stabilize carbon emissions to 2019 levels by requiring airlines to offset the growth of their emissions starting from 2020. So from 2021 to 2023 has been the pilot phase of this program, and from 2024 to 2035 will be the second, third, and the fourth phases of this program. The baselines are set to 2019 levels for a reason. Initially, they were planning to go by the average of 2019 and 20, but because COVID was an odd year in terms of air travel, amongst other things, they finally settled with 2019 baseline, and that baseline is followed for all monitoring and compliance purposes. The last I checked ICAO's website, there were 150 member states of the ICAO that agreed to participate in the COSIA mechanism. And COSIA applies to only civil aviation, and it excludes aircraft that are below maximum takeoff mass of less than 570 kilograms. Then all the firefighting, medical, and human operations are excluded from COSIA. Likewise, small operators whose total emission in a given year is less than 10,000 tons are also exempt from COSIA. So only the medium-sized aircraft that are into international aviation are covered by the COSIA mechanism. ICAO adopted COSIA through SAPS in 2018. And like I said, there has been a plan for its phased implementation. There's a verification, monitoring and reporting mechanism in place. I'm not getting into the details. And there's a carbon offset criteria which is dictated by ICAO's technical advisory body to ensure the compliance. So the mechanism is in place, a global mechanism is in place, but are they effective? Are they on paths to achieve the goals they are set out to achieve? That's being debated in the international community at ICAO and at European Union. The critics argue that offsetting does not encourage direct emission reduction. It's sort of a mechanism for just easing the guilt, ducking the responsibility. You give money to something else in place of you assuming greater responsibility in terms of bringing in new technology that actually bring in sustainable change is actually ducking the responsibility. Then there are concerns of quality and integrity of offsetting projects, of companies that these airlines give money to. Are they actually doing their work, and are this project that these companies or mechanism implement on ground really contributing to climate change? In the level of the pollution that these airlines causes? These are questions that are often being asked. Then there are critics who argue for tougher laws, who criticize the voluntary nature of COSIA, at least during its voluntary phase till 2026, wherein it is not really productive in terms of its stated goals because of this voluntary nature of its implementation. Then it's also criticized for its differences in regional and national climate policies, because many countries who've already stated their policies in terms of their compliance with the Paris Agreement would find it difficult to change it based on the new targets that CORSIA may give at a later point of time. So India, its initial stance were against the implementation of COSIA. Country never supported COSIA when it was initially discussed at ICAO. But lately, to be precisely from last year through this year, we have been slowly warming up to agreeing to COSIA and have made announcement to the effect that by 2027, when the mandatory phase of COSIA begins, we will start implementing. But the list of countries who are participating in COSIA that's available on the website of ICAO still doesn't mention India or Russia or China. And Russia is very vocal about its opposition to COSIA at ICAO from the very get-go. So that's basically what ICAO is and what our country's stance is on COSIA. Beg your pardon. Now we'll move on to briefly explaining what the emission trading mechanism of the EU is. The European Emission Trading System, the EU ETS, it's the cornerstone of EU's policy to combat climate change through a cap and trade mechanism. How it's different from COSIA? COSIA doesn't set a cap on airlines at the sectoral level or at the airlines level in terms of the amount of pollution that particular airline or the airline sector can cause. But Europe has gone for a stricter standard. It is decided on a sectoral level cap, not just on aviation, but now ETS applies on shipping, power industry, and all those industries that are intensive on carbon emissions, like steel, aluminum, etc., that operates within the jurisdiction of EU member states. So that now applies to uh, European aviation as well from 2012. And interestingly, Europe has its own notion of what international law is. You must have, those who've done international law at your undergraduation level would know that international law is Eurocentric, etc., etc. So here there is some Eurocentric notions, modern Eurocentric notion about who this law applies to, and Europe interestingly decided that it applies to even non-European airlines that operate within EU. But because of the opposition that they met out in both in ICAO and in other aviation forums like IATA, they decided that they are only applicable to intra-European airlines, and they have been implementing that in a phased manner. But ICAO is still critical about European trading scheme, primarily for the reason of because of the recent announcement that European Parliament made on this regard. They said that they, in not so indirect terms, question the integrity of COSIA, and they said that they will kind of review COSIA's implementation and see if they can bring back, if there is a need to bring back the application of ETS to trans-European airlines as well. So that has ruffled a few feathers both in ICAO membership and IATA. And if you do a cursory search on this matter online, you would find statements made right from the top of IATA, from its vice president, to statements made by member states at ICAO on this matter. So that's it. That's what I intended to do. I wanted to briefly present you these two systems that now dictate global efforts as regards carbon offsetting. In fact, as regards carbon reduction mechanism in aviation, COSIA, and the EU ETS. Thank you very much.
Thank you so much, sir. I think even after almost, if we include all delegates, having flown from a minimum of 3 states, if we can still talk about aviation and emission, that still shows a lot of spirit of climate advocacy. And now I would like to call upon one of the most senior members on our panels today, Dr. Sachdeva sir. He is currently a professor at Nalsa University of Law and a former adjunct professor at Jawaharlal National University in New Delhi. He brings vast experience that has to be unparalleled, and he'll be speaking on the notion of new interpretations of onboard aircraft for passenger liability.
Thank you very much for this opportunity to talk to you all on a subject which is quite dear to me. In fact, I started working on air law way back in 1977, and my first article appeared in 1981 in the Indian Journal of International Law. So talking today is on a very specific sort of a thing under the Liability Convention. I'm talking on onboard aircraft. Actually, onboard aircraft is a very common word. We get into the aircraft and we say we are on board. In fact, aviation, if I take you back, aviation started not only with heavier than aircraft. Aviation started much earlier, and if I put it, it started in 1909. It was sponsored by Graf von Zeppelin. He was a German enthusiast for air and a big magnate, lot of money, lot of money. And he started aviation, flying actually, commercial. I'm using the word commercial flying, with what we call today is blimps. Now, blimps were something like a gas-filled balloons with which you could create airlift. And underneath that was a gondola in which you could have the passengers. And the gas filled was either hydrogen or helium. In 1909, when he started off with it, it was a great success. It was a lead mode of transportation and it became international. It became international. But unfortunately, about 6-7 years later, after he had been into this particular aviation sector, there was an accident of one of the blimps which was called Hindenburg. And the accident happened at a place called Lake Constance. There were few people within that gondola who died. But the claims were so high that Zeppelin, despite being one of the richest tycoons of Germany, went bankrupt. Now I take you from this sort of a aspect to the modern aspect. And when it came, why he went bankrupt? Because of the unlimited liability under the tort law. Under the tort law. Now, later we had in 1929 what we call as the Warsaw Convention. And the Warsaw Convention established that you cannot have unlimited liability because it becomes very indeterminate. Indeterminate with respect to the passengers. Who will claim what amount? And even insurance is difficult. And taking you way back, in 1929, insurance was very heavy. Insurance was very heavy at that time. The premium was very high. So actually there was a limitation on liability, but along with that came the word on board. That means liability for a person would arise if the aircraft meets with an accident and there is an injury or bodily injury. I use the word bodily injury or death of a passenger. That is what happened. And it said on board. Now, what was on board? When your name goes on the manifest, when you climb the stairs to the aircraft, or when you are settled in the aircraft, or when the engines start, or when the doors close. What is the occasion, what is the timing when a person becomes on board? So that he can claim for an air accident under the liability convention. Now, all these factors change with the changing aircraft and all that, because in 1929, the aircraft were very small. They could take off from a small paved sort of a runway, and they didn't need what we have today. So it was very easy. Liability is created once the flying accident happens. But flying accident is not the only occasion in modern times. Today we have reached a stage of modernity where air terminals are terribly big. I use the word terribly big because some of them are so labyrinthine where you got to walk almost miles to reach the boarding area. Today, it's not only the aircraft, but from the terminal to the aircraft, you are quite often taken in a road transport. And road transport was eliminated from liability. So apart from that, there are occasions where accidents can happen within the terminal area itself. And today, we need to be within the terminal areas as we are directed to report 2 to 3 hours before. foreign travel 3 hours, domestic travel 2 hours. So that means you are within the terminal area or up to the boarding to the aircraft for 2 to 3 hours in that. Now what really happens is that these 2 or 3 hours which you are at the airport, anything can happen. Anything can happen. I'm not defining what. And if I were to define one, there was a case of an aircraft terminal where the roof fell down. Where the roof fell down. And when the roof fell down, some of the passengers got injuries. Now this case went to the United States court. And the court said, yes, why not? You were there because it was an incident of your air travel. And if it's an incident of air travel, that means your air travel has started by the time you enter the airport. And the US courts, devised a three criteria test to find it out whether this particular gentleman or this particular passengers, why was he inside? First question raised was, where was he? Was he within the terminal? Was he traveling to the airport, aircraft? Because aircraft are normally parked on the tarmac and road transport takes you to that place. Or is it that you are inside for a purpose? So the second criteria was that the person is for what purpose? Why is he there? Because he is to fly. And that means the liability for air accident could have started from the time he enters the terminal. Why it is said is because airport terminal is a sanitized area. From the time you enter, it's sanitized. And there was a case of where there was a terrorist attack within the terminal. So the question came up, if there was a terrorist attack, this was a sanitized area, the passenger should have been protected. Passenger should have been protected. First I gave you the case of fall of the roof. Now I have given you the case of a terrorist attack. Similarly, there are a lot of situations which can create injury or death. And it's not only that. Within the airport, you use a lot of facilities like lifts, escalators, walk-elators, and various other things. And if I give you another instance, there was a case in Palam Airport where a small little girl got killed while on the escalator. Very clear case. In this case also, I'll discuss a little later. Now, when I was talking to you on that criteria created by the US courts because of the major cases happened in the United States, and United States courts are very reasonable. I use the word reasonable because they are, I won't call them pro-passenger, but I call them they reasonably accept the necessity. So where was the passenger at that time? What was he doing? And under whose control was he? That's what normally happens. We walk into an airport and the airline staff tells you, please walk into this airline and check in and walk in here and go to this security area, go at this side and then you go for immigration and things like that. So the United States courts said that yes, the moment a passenger enters an airline area or enters the air terminal, it becomes a case of air accident. Now the question came, how can the airline accept some sort of a damage? And there, the Indian courts have done better. They said implead that particular airport authority or the people or the authorities or entities which operate your conveniences, walkolators, this, that, and all that. So the US courts accepted, it's perfectly fine. It will be deemed as an air accident from the time you enter. It's a sanitized area. You are under control. You are told where to be. You are told to wait at the boarding gate. And all that is within the control of the airline. So airline is liable. And as per this, your basic onboard starts from the time you enter the air terminal. That is what should be as per. In fact, the same question came up in the case of that little girl in the Indian courts. They said it was not our fault. They said it may not be your fault. But the fact is, you have been the one who's contracted out these facilities, or you have outsourced these facilities, and you are taking from them, for your own passengers. And in this particular case of the little girl, the Indian court said, if necessary, implead whichever authority you want to, whether the Airport Authority of India or that outsourced or the contract, wherever that existed for the particular escalator. So we have reached a stage today where onboard is not merely a flying accident. Onboard starts from the moment you enter the terminal, because you are within the control, you are within the purpose, and your justification for being there is travel, the incident of travel. The incident of travel. That's what brings you there. And since that brings you there, that means liability starts from there itself, and not only when you get onto the airline's aircraft. Now I have tried to give you, in fact, my slides have some of the actual cases where these instances have occurred. But basically what I'm trying to sort of excite the brains of the youngsters, try to think out of the box. Don't take what the convention says. Think what the convention says is right, or have the circumstances changed? We have gone far ahead of what the convention was. 1929, 1999, we are still 25 years ahead of Montreal Convention. And Montreal Convention was silent on this aspect, despite this having been debated in the United States. Let's wake up to the present realities. And I urge all the young students to take up incidents and cases, maybe small or big, where we need change. It's a change of thought, it's change of mind, and change of mindset. Thank you.
Thank you so much, sir, for giving us such a comprehensive debrief on probably one of the most pivotal aspects of air travel, that is passenger safety and passenger liability. And for the concluding panel discussion for this session, now I would like to invite Dr. Banerjee. Sir has been a professor of law and dean at the VIT School of Law, and sir has played a very crucial role as the legal advisor for one of the most important organizations, that is International Committee of the Red Cross. I invite sir to give his panel presentation on international legal and regulatory issues of unmanned aerial vehicles.
Thank you very much, and good afternoon. I think it's 11 minutes past 1 o'clock, and all our hunger pangs are ticking. During that time, if I speak about the unmanned aerial vehicles, it may not make sense. But however, I'll just take in a few minutes and leave some of the issues what I wanted to discuss. Before that, I would like to thank Professor Sandeepa Bhatt for inviting me to be here in this August gathering. And also I'm very pleased to thank our MNLU Mumbai Center for Air and Space Laws, and also GNLU Professor V.S. Mani's Special Center on Aviation and Space Law, because I'm very close to Professor V.S. Mani, being a student of him. And also I'm thankful to my co-panelists for bringing the issues. And particularly this room, we can witness the generations of aviation and space lawyers, starting with Dr. G.S. Sachideva, who was a senior most person in aviation law, and followed by some of our friends, those are working in elsewhere, and now the new generations which is taking up. So when we have taken, I think most of the people, they talk about that, what fascinates you in aviation law or in international air law. So the basic fascination was, it takes you to the entirely different world. Today, when we are talking in 2023, we talk about that unmanned aerial vehicles. But if you look at it, the remotely operated aviation mechanisms, so pilotless aircrafts, which was discussed way back in 1944 when the Chicago Convention was talking. So that's the kind of fascination which you generate. 1942, 1943, during the war periods, when people want to have a regulatory mechanisms in the aspect of Chicago Convention, they could able to envision there are air carriers where you need not require to have a pilot, and pilotless operated air carriers, like Professor Sachideva has already explained about the Zeppelin and the incidents which took place. So from there, we have grown, and now we have come to the most advanced system of unmanned aerial vehicles. Now today, we need to look at it how far this is going to be viable, and if it is viable, and what could be the legal and regulatory framework which we need to look at it for the regulation of unmanned aerial vehicles, that UAVs. Okay, now coming to that, the first, the most interesting aspect is that, let me tell you my experience yesterday. I started from my home in the morning, 5:45, reached the airport. After waiting almost for 3 hours, then they said that your air carriers got delayed by 1 hour 40 minutes. And yeah, it's cancelled subsequently. Then later they came back and told me that no, it's not cancelled. There is some technical snag, and it's coming from Hyderabad, and we'll take you. Eventually, what happened after waiting 3.5 hours over there without any offering any kind of services by the either staff or the airport, and we were just stranded. No clue what's going to happen. It did not stop there. And it is a very bumpy ride, and a lot of things which went on. One of the greatest airlines there. And after reaching in Hyderabad airport, and to my courage and spirit to come here on time, not to miss my flight, I made all my efforts to reach the boarding gate and the connecting flight Vistara. They said that, sorry sir, it's just pushing back. Let's see there. And I can't help it. Then finally I called our friends in Aditya and I said that, guys, this is out of best my efforts. I could not able to do it. But they have to book another flight, and with the whooping money. And then I had to wait almost 4 hours in the Hyderabad. And finally I landed 9:30 in the Bombay. So that's the kind of system what we are in 2023. So this is also very fascinating experience. Why I am narrating that fascinating experience? Number one, we have that rights of the passengers, but we did not me being aviation law student, could not able to do anything. Number one. Number two, my flight got delayed, and because of that particular delay, I had to lose the money, and it's a lot of money. And now I don't know what I'm going to do. I would request the Center for Air and Space Law here, MNL, you take up that issue as a consumer issue. Because I lost the money, and they denied my boarding because of, there is 2 minutes of, whatever that lag time. And subsequently, and I had to pay another whooping money. It's a huge expensive if you book on a same day within hours before it. So what kind of rights we have? That's a very good area. That fascinates me every time to look into the aviation law. Now, another aspect which is again fascinating to us, do we not have the legal mechanism to address all the kind of trauma what it went on? It is there in the aviation law, Warsaw Convention, Montreal Conventions, and other protocols we have. But how far we are aware of it? So that is why since morning every one of us are saying that youngsters must take, and this is I am informed person like me, I am experienced like that. Imagine that in crores of citizens, those who are traveling, we need to do something. Because of that, today we are talking about most advanced technology which can have the efficient, safe and reliable air travel. That is what where we are coming up, unmanned aircraft system. So this is a new component of the aviation system. And now the states and the aerospace industry is thinking about that, can we have, when we can think of 1942 and 1943 to have the pilotless vehicle, why cannot we think of today to have that kind of mechanism? This is based on the cutting edge development of aerospace technologies, offering a kind of achievement in the new imported civil and commercial applications, as well as an improvement in the safety and efficiency, which is one of the cardinal principles of aviation law. That is in Article 44 of the Chicago Convention, where the International Civil Aviation Organization tangibly is addressing the safe, reliable and most efficient way of secured mechanisms of an aviation air travel to the passengers, and without wasting much of economics and efficiency. The articles which also says that we need to avoid undue wastage of economics because of the competition, because of not reaching up to the level of having a cutting edge technology. So the safe integration of this have to made long-term activity within various things. Now, if you look at that, civil aviation, unmanned aerial vehicles, we'll come back to that little later. Now we can see that unmanned aerial vehicles like drones, we have the different categories of the drones. Like a drone which is 90 grams, drone which is categorized as 250 grams and less than 4 kgs, and the highest level is that now we have less than 90 kilograms and also 250 kilograms. It has been designated by the airworthiness officers and various avionics and recognized by the various legal mechanisms under the domestic as well as international legal mechanisms. Now the problem here is that what are the issues which we invent that into the aspect of civil aviation for the commercial purposes. Now that is an issue we need to look at it. How far it is going to provide an advantage? And they do have an advantage because they make a stronger case for the robust civil government and commercial market to reap the benefits of lot of wastage of the money and economics and the efficiency. Now if a pilot you want to engage, like a morning our speakers have told, India is the one country which are investing a lot in the aviation sector, and Air Vistara as well as Air India, they ordered almost 1,500 air carriers, and it is going to delivered in the span of 10 years. But do we have the personnel for that? The first question, do we have the trained pilots to use that particular benefit? And India is going to go into the aviation market in a big way in the coming days, and now it is systematically increasing. If you look at that in a Delhi airport in 2021 and 22, the footfall of that Delhi airport is 48 million per annum. Now, next another 2 to 3 years down the lane, it is going to touch upon 65 to 68 million passengers are going to travel. That's the kind of system what we are. Now, do we have the efficient pilots who got training? And also, we need to see that their worthiness to command the flight in all kinds of situation. Because of that, the problems of the existing in nature, we need to look at it how far it is going to be viable for the commercial purposes. Now, as I told you that Article 8 of the Chicago Convention already mentioned about the pilotless air carrier, and also Article 31 and Article 32, it is already there. And why we cannot look at it those aspects? But some of the naysayers, they say that we have the issues. Yes, we need to take into the issues in consideration. First one is that the high acquisition and the operational cost. That is the first thing we have to look at it. The second thing is that liability cost, high insurance and liability cost. Lack of unavailable and available protected frequency of the spectrum to run that UAVs, and poor reliability and record of the UAV systems and their operations, and a lack of effective and affordable collision avoidance system which is capable of detecting and non-transport equipped aircraft. So these are the problems which are narrated by the number of people, those who are working in the avionics and aviation technology. But so there is a kind of lack of consensus on that with regard to the operational concept is concerned. But still, what I would like to say that when the military air carriers can use in such a speed and such an accuracy, we have medium range the combat air carriers, like we have that Dragons and Hawks and Hawk. There are so many names are there. And when we have that one, why we cannot have the high altitude the air carriers in the context of the system? So military is entirely different, but when it comes to civilian air carriers, we need to have the utmost safety, security are the prime conditions, how we are going to look at it. So for this purpose, what I would like to draw the parallels from the Chicago Convention and its annexes what we have, the 18 annexes. Annex 1, Annex 8 and Annex 11, which clearly talks about that what the conditions we need to deploy for the purpose of having the airworthiness, and also the issues which we are going to focus on what people are saying about that. So that is why we need to revisit the existing regulatory framework, and that regulatory framework is able to provide some kind of a mechanism to have the more viable commercial unmanned air vehicle system, where it can be used for the purpose of getting the efficiency. And apart from that, we have that recent regulations provided by the International Civil Aviation Agency, particularly that is ICAO 9564. That is a one particular general recommendation given, which clearly says that global air traffic management and operational concept, which says that the unmanned aerial vehicle is a pilotless aircraft, is sense of an Article 8 of the ICAO, the Chicago Convention, and it is fully controlled from another place, either ground or other aircraft or space, which programmed in a fully autonomous system. It is more reliable. So that is what ICAO is started working on that, and they are coming out with various proposals. Look at it, in 2005 itself, the International Civil Aviation Organization has started working. Today in 2023 we are speaking about this, but 2005 itself they could able to envision the future of the technologies and command and control system of how we are going to control these particular aspects of the unmanned aerial vehicle. And the last point what I would like to say that if you look at that track record of the ICAO, that is they have a group of experts that support various mobility transportation system. Number one, remotely piloted aircraft system panel, RPASP, that has been working since the 1952 onwards, which is working to provide the guidelines on a remotely piloted aircraft system across the world. Imagine that 1956 onwards, the RPASP is working. Now we have the another group called Advanced Air Mobility Study Group. They are also working about that sustainable integration of the both manned, unmanned aviation commercial air carriers in the context of the International Civil Aviation Organization. And the last one is that the Unmanned Aircraft System Advisory Group. It is headed by the state management. They are now trying to develop unmanned aircraft system traffic management and also the carriers, where they can synchronize both the manned and unmanned and give that a specific designated airspaces for both of them, so that we can reap the benefits of both the systems. That is what now currently they are doing that. So based upon this particular work of the International Civil Aviation Organization, what I can confidently tell that aviation community, and now the day has come, we need to look at it, the kind of availability of the cutting edge technology. We need to reap the benefit to build not only that unmanned aerial vehicles, but also rapid urban transport mobilization, like airports, what we have come. And yesterday we have seen in the one news, and in Bangalore somebody already started the airport system. For that we need to have the very ports. Very port means where is a kind of landing ports where the airports come and pick the urban transportation. When such kind of transportation which is coming, how are we going to regulate? So the regulatory mechanism has to be in the place. And already the European Union has in 2013 has adopted certain regulations in the European level. And 2021, India has also come up with the rules, draft rules with regard to the operation of the drones. And since the countries are working on that, it is a time to think about having possible viable unmanned aerial vehicles and also urban rapid transportation system to suit the needs of the people and reap the benefits of the aviation community. Thank you very much.
Thank you, sir. I think right after the conference, Aditya sir and Center will definitely be taking up the issue of cancellation of your flights. We'll definitely look into it, sir. And I think I can only say as much as a thank you for, we are honored to have such a diverse set of panelists speaking on issues ranging from climate change to aircraft financing. And thank you so much, sir. We'll now be having lunch and we'll again resume after 1 hour. The volunteers outside will be assisting everyone about the places for lunch. Panelists and resource persons lunch will be served on the right side of the venue and the lunch for the attendees would be served on the left side of the venue. Thank you, everyone.